If you're involved in a trust dispute, or you think you might be, one of the first questions any attorney is going to ask you is, do you actually have the legal right to bring this claim? That's called standing. And in California trust litigation, it is the gateway question. Get it wrong, and a court won't even hear the rest of your case. I'm Ben Fox, a California trust and estate litigation attorney with Fox Law. Today, I want to walk you through who has standing in a California trust matter and what you need to know before you take any legal action. Standing isn't about whether your claim is valid. It's a more foundational question that has to be answered before any other question. Are you legally recognized as someone who can even raise this issue in court? California trust litigation is governed primarily by the probate code, and the probate code is pretty specific about who can petition the court, who can bring a claim against a trustee, who can challenge the validity of a trust. The key phrase you'll hear is legally cognizable interest. That means your interest is to be real, direct, and capable of being affected by the outcome. Feeling like things are unfair isn't enough. Having a last name on the family tree isn't necessarily enough. You need a legally recognizable stake. So who does qualify? Let me walk you through the main categories. First, beneficiaries. If you're named in the trust either as a former beneficiary, current beneficiary, or as a future contingent beneficiary, you almost certainly have standing. Your interest is built right into the document. Even if you were a beneficiary under an earlier version of the trust and you believe a later amendment is invalid, you likely have standing to contest that amendment, even though the amendment completely disinherited you. Second, heirs at law. These are people who aren't named in the trust but who would inherit under California intestacy law if the trust were set aside. Intestacy is old jargon that roughly means next of kin. For example, an adult child who is completely disinherited from a trust may have standing to contest the trust's validity, not because the trust gives them anything, but because the law would through intestacy if the trust didn't exist. Third, trustees. A trustee generally has standing both to defend the trust and in the right circumstances to bring claims on the trust's behalf. If a prior trustee mismanaged assets, the successor trustee often has both the right and the obligation to pursue those claims. Here's something that surprises a lot of people. Standing isn't just about who you are. It's also about what you're asking the court to do. For instance, you might have standing to demand a trustee's accounting, but not have standing to challenge a specific distribution. This matters a lot when you're deciding how to frame your claim. And it matters strategically too, because challenging a person's standing is one of the first moves a skilled defense litigator makes. If the opposing counsel can knock you out on standing before the merits are ever heard, they will. There's also the no contest clause issue. These are clauses found in almost every California trust document, and the general goal is to discourage people from contesting the validity of a trust document. If you do contest the validity of a trust document and you lose, and a court finds you lacked probable cause, you could forfeit your entire inheritance. That's a real risk, and one of the reasons why standing has to be analyzed early and carefully. Let me share a few of the most common standing mistakes I see. First mistake, assuming that simply being a family member is enough. Courts don't necessarily recognize standing just because you're a family member. Standing is based on having a legal interest. Second mistake, waiting too long. Standing and deadlines are connected. California has statutes of limitations for trust contests and notice requirements that can cut off your rights if you don't act. I've seen people who have standing and legitimate claims lose the ability to bring those claims simply because they waited to see how things played out. Third mistake, thinking that because you have standing for one type of claim, you then have standing for all types of claims. I'd often have to advise clients on where their standing starts and stops in regard to specific issues. Trust litigation is complicated, and standing is one of those issues where getting it wrong at the beginning can cost you the entire case. If you're wondering whether you have the right to bring a claim, or if someone is questioning your right to be involved in a trust proceeding. That is exactly the kind of question we work through with people every day at Fox Law. We offer an initial no-cost consultation, no obligation, just a straightforward conversation about whether you have standing and what your options are and what the path forward might look like. You can reach us through our website, foxtrustlaw.com. Thanks for watching.